And then there is the auction of 2 homes, which, according to the land registry, had already been registered in the name of the Belgian State since 21st February 2020, but were nevertheless auctioned by ING. When the land registry is called, the answer is clear. The Belgian State is registered as the title holder. That means that the state is officially the owner of both properties.
Ja, dat staat wel sinds 2020 inderdaad. Belgische staat, zie ik hier. Bij titularis staat er Belgische staat. Mevrouw dus gaat volgens mij pre-adicendum imoverkocht zijn.
And that is essential. Because when the Belgian state sells a property, it does not happen through a bank, but through the official Finimo web procedure. Even the land registry confirms this. Then it would have been sold through Finimo web. That is the normal route, but that is not what happened here. It appears that, according to the bailiff, the properties were still ours in 2023. But that was not true. The Belgian state had already had the properties registered in its name on 21st February 2020. ING could never have initiated the auction if the bailiff had not made that declaration. That is why the auction procedure was conducted against us and later recorded in the mortgage register as if that reflected the actual situation. Without that declaration by the bailiff, which presented an incorrect picture, ING would have had to bring the procedure against the Belgian state and not against us. In other words, if there were burdens, they were placed on us. But when it came to proceeds, the Belgian state was named.
Wij moeten niet nagaan of dat goed nog van jullie is. Dus zij brengen het bij ons binnen. Wij moeten enkel nagaan bij een uitvoerende beslag of dat er een voorgaan uitvoerende beslag op dat desbetreffend goed nog ligt. En dat was niet in dat geval. Wij leggen dat neer. Dus de deurwaarder moet eerst zijn werk doen en lang kan ik de slag leggen op dat goed. Is dat goed nog van die? De deurwaarder moet van tevoren nagaan op welk onroerend goed we beslag kunnen leggen. Ja. In de zin van welk onroerend goed is eigendom. Ja, yes.
Yet this fundamental contradiction is nowhere examined. On the contrary, through opposition proceedings and summary proceedings, we tried to put this reality before the court with documents and evidence, but it was simply set aside. The core of the case remains unanswered. What remains is a procedure in which the facts are submitted, but not examined, as if the outcome had already been determined before the substance was ever truly considered. On 6th March 2024, we were evicted from our home by the Belgian state. And on that exact same day, ING initiated the next step, the appointment of a notary to auction the homes. While the state acted as owner, the bank acted as if that ownership did not exist. What stands out is that the actions of the Belgian state and ING fit together seamlessly. The state carries out the eviction as owner, while ING simultaneously organizes the sale. And even more striking, a public authority, the COIV, grants ING permission to auction the properties. This leads to one fundamental question. How can a private bank sell a property that, according to the state itself, already belongs to the state? And, remarkably, it is ING itself that submits this document in the summary proceedings. In an email from the Belgian state, it is confirmed that it will not oppose the sale of the properties by ING, while that same state is registered as owner according to the land registry. At the same time, it stresses that its rights must be respected and that it wishes to be kept informed of the further course of events. In other words, the state recognizes its position, but allows the sale by the bank to proceed, raising the fundamental question of how a bank can sell what, according to that same state, already belongs to it. This creates a situation that cannot legally exist. A state that is the owner, a bank that sells, and a procedure in which that contradiction is not resolved, but ignored. And so only one question remains: who owned these homes at the time of the auction? Without an answer to that question, this sale cannot have a valid legal basis. And precisely there the next problem arises. how is something like this processed administratively? How do you record a sale in a system when the underlying ownership itself is contradictory? After the auction, another phase begins. Not a phase of clarity, but of silence. A notary in Antwerp carries out the sale on behalf of ING, but everything is missing. No transparency, no complete documents, no communication. We are informed of nothing. Not about the course of the sale, not about the price. We only discover the sale when bid-it signs suddenly appear on the properties, not through a letter, not through the notary, but on the street. The documents that do arrive are fragmentary, loose pages, never the complete file. At the same time, there is a notary in Weald who, for years, did provide information about the mortgage statements, without any problem. Until, there too, the door suddenly closes. In an email, it is written in black and white. No further information may be provided because we are no longer the owners. But that is exactly where the rupture lies, because that same notary had previously provided that information, without limitation, without invoking any duty of discretion. What changed? Not the facts, not the ownership, only the access to information. And meanwhile, the most important thing is missing. The properties were supposedly sold in November 2025. 6 months later, there is still no settlement, no sale price, no distribution, no clarity about any possible remaining equity. Although the notary wrote weeks ago that the settlement would follow shortly, everything has remained completely silent since then. No communication, no follow-up, as if the file is being deliberately pushed out of sight. This makes it all the more distressing that crucial elements are entirely absent. Nowhere is there any mention of the serious mold problems, with a reduction in value of almost 1 million euros. No analysis, no transparency. At the same time, there are 2.5 years of mortgage payments that ING simply received, but there too, everything remains silent. No settlement, no explanation, no set-off. And we were never informed that the properties had been transferred into the name of the Belgian State. That happened entirely in silence. When the value, the payments, and the ownership itself all disappear from the story, only fog remains. And this is where everything comes together. There is a partial confiscation, which means that any surplus must legally be established and distributed. But on that point too, there is silence. The mortgage registry office gives no answers. The executing notary refuses access. And those concerned are left without access to their own file. What remains is a system in which everything happens: seizure, eviction, sale, but in which no one can still explain on the basis of which ownership, which value, and which settlement. Because if the state was the owner, this should have proceeded through Finimo Web. If the original owners were still the title holders, the cadastral register should have shown that. But both cannot be true at the same time, and yet that is exactly what happened here. And so, in the end, only one question remains: not only who owned these homes, but what happened to the value, the payments, and the proceeds of this sale? As long as there is no answer to that, this is no longer a file, but a system in which ownership, enforcement, and truth have completely fallen apart.